Could you all take your seats, please? Or at least quiet down as you get the last few slices of pizza, and we'll get started. Good afternoon. My name is David Hamilton from the United States Court of Appeals for the Seventh Circuit. On behalf of the Office of the Provost, Lauren Robel, the Indiana University Maurer School of Law, and the American Constitution Society, I'd like to welcome you all to the celebration of Constitution Day 2014. On this day in 1787, the delegates to the Constitutional Convention gave a collective sigh of relief after a long, hot summer in Philadelphia behind closed doors and windows. And those of us who've spent summers in the Delaware River Valley know just how hot and humid it could be. The final product was a compromise. I don't believe any delegates actually endorsed it with enthusiasm at that time. It was far from perfect. Its greatest failing was, of course, its tragic compromises regarding slavery, which planted the seed for the American Civil War. Yet over that summer, those delegates from the Confederated States had managed to agree on a Republican form of government that would enable this republic to survive and even to flourish. They solved a lot of problems that we no longer worry about, and they agreed on a framework that has been flexible enough to cope over more than 2 centuries with extraordinary changes, with expansion from the Atlantic seaboard to the entire continent to the Pacific Ocean, with economic revolutions that took a largely agricultural society through the Industrial Revolution of water and steam power to electricity, telecommunications, internal combustion engines, and the modern computer and information age. And from an economy dominated by individuals and small partnerships to an economy dominated by large and even multinational corporations. It copes with the changes from a society that had been dominated by white Christian men of British heritage to a society that has eventually made room to recognize the civil rights of women and people of all national origins and ethnicities and faiths. It has coped with the expansion of our concepts of what government should do in an ever more complex society, from guarding the coast, collecting tariffs, and delivering the mail at the beginning, to providing for education and effective law enforcement, from protecting us from tainted foods and drugs, to now protecting us from modern identity theft, from virtually no economic or environmental regulation to widespread efforts to protect the environment, to provide for fair and honest economic markets, including labor markets, to protect us from the vicissitudes of the economy, old age, and poverty, and from providing what was then a very primitive military umbrella for state militias to standing armed forces that are now the most powerful military the world has ever known. All of that within the framework that was created back in 1787. One of the most compelling lessons from this history is that the final version in September 1787 was, of course, a compromise, a word that has loaded meaning in our modern political environment. The final version was not even close to what the principal designer, James Madison himself, had envisioned. But despite all the compromises and the failings and imperfections that were perceived, there was a powerful message from Ben Franklin on the last day. This was the last major public effort of his life, and he was on that day too feeble to deliver the speech himself, but he had written it, and he asked his fellow Pennsylvanian, future Supreme Court Justice James Wilson, future Supreme Court Justice and future fugitive from creditors, as it also happened in our early nation, but Wilson read it for him. His message is powerful, I think, for all of us about the Constitution and our political life. Here's part of what he had to say. Mr. President, I confess that there are several parts of this Constitution which I do not at present approve, but I'm not sure I shall never approve them. For having lived long, I have experienced many instances of being obliged by better information or fuller consideration to change opinions even on important subjects, which I once thought right but found to be otherwise. It is therefore that the older I grow, the more apt I am to doubt my own judgment. Think about how that was heard by delegates who knew him as the wise statesman of the nation. I consent to this Constitution because I expect no better and because I am not sure that it is not the best. The opinions I have had of its errors, I sacrifice to the public good. I have never whispered a syllable of them abroad. Remember, the convention was under a an oath of secrecy. Within these walls they were born, and here they shall die. He then urged his fellow delegates to approve the Constitution, to use their influence to have it ratified, and then to, quote, turn our future thoughts and endeavors to the means of having it well administered, a project we are still at today. His final words could also inspire us today. On the whole, sir, I cannot help expressing a wish that every member of the convention who may still have objections to it would, with me on this occasion, doubt a little of his own infallibility, and to make manifest our unanimity, put his name to this instrument. And they did, and we are better for it. Our distinguished speaker today is unsurpassed in his understanding of the origins of this document, its genius and its flaws, the living history of its role in our collective governance over the last 2 centuries and more, its challenges for us today, and the prospects for its future. Over the last 13 months, he's been immersed in one of the great fields of current constitutional debate, that posed by the surveillance and information gathering activities of the National Security Agency and our larger intelligence community, with their effects on both our security and our privacy and liberty. Professor Geoffrey Stone is the Edward H. Levy Distinguished Service Professor at the University of Chicago. He graduated from the University of Chicago Law School. As editor-in-chief of that distinguished law review, I learned with a little help from our own Fred Amon years ago. He also clerked for D.C. Circuit Judge Skelly Wright, one of the judicial heroes of the civil rights movement, and then for Justice William Brennan, who helped reshape constitutional law, particularly with respect to civil rights and individual civil liberties. Those topics have been at the center of Professor Stone's writing and teaching since he returned to Chicago in 1973. He has served as the dean of that law school and as provost of the University of Chicago. He's a member of the American Law Institute, a fellow of the American Academy of Arts and Sciences, the National Advisory Council of the ACLU, and for several years served as chair of the board of the American Constitution Society. He is the author of, quote, many, close quote, books on constitutional law, and too many articles and talks for me to count. And of course, in August 2013, in the wake of Edward Snowden's disclosures about surveillance activity by the NSA, one of Professor Stone's former colleagues on the Chicago law faculty, now President Barack Obama, turned to Professor Stone as one of the members of his President's Review Group on Intelligence and Communications Technologies, which may have something to do with his talk today, I hope. So, one aspect of modern law is the tendency towards specialization and isolation, more and more jargon, as law practice, and we get this isolation within law practice and scholarship and among courts, the practicing bar, and the academy. Professor Stone's career resists those trends. He exemplifies the public scholar, lawyer, and intellectual. He is a bridge between the academy and the bench and bar. He writes briefs to persuade courts. His scholarly writing influences the academy and at least sometimes the courts. And with his exceptional ability to teach law, his many essays for the Huffington Post, among other places, illuminate the law for citizens who are not burdened with a legal education. We live and practice in a legal world dominated today by a Supreme Court that is far more conservative than the court of 50 or even 40 or 30 years ago. One of Professor Stone's contributions to legal debates is to remind us how broad the field of our debates can be and should be. So I want to close this welcome with a quotation from one of his recent articles called Selective Judicial Activism from 2011 that made this point. He said, I sometimes wonder what constitutional law might look like today if justices with the same vision as Justice Brennan had remained a majority on the Supreme Court over the past 40 years. It has been so long since there has been a liberal majority on the court that it's difficult even to conceive what a liberal jurisprudence might look like today. Here are some possibilities. The counterfactual court might have held not that affirmative action is unconstitutional, but that it is sometimes constitutionally required. It might have held not that cigarette companies have a constitutional right to shield their products to children, but that children have a constitutional right to an adequate and legal and equal education. It might have held not that silence constitutes a waiver of the right to remain silent, but that individuals accused of a crime have a constitutional right to DNA testing. It might have held not that the government can constitutionally ban partial birth abortions, but that it cannot constitutionally ban stem cell research in order to enforce the faith-based beliefs of the religious right. And it might have held not that corporations have a constitutional right to spend millions to buy the elected representatives of their choice, but that public officials cannot constitutionally use partisan gerrymandering to ensure their perpetuation in power. It might have held not that the Boy Scouts have a constitutional right to discriminate against gays and lesbians, but that gays and lesbians have a constitutional right to marry. And with a final word then about methodology, he wrote that constitutional interpretation is not a mechanical, value-free enterprise. It requires judges to exercise judgment. It calls upon them to consider text, history, precedent, values, and ever-changing social and cultural conditions. It requires restraint, wisdom, wait for it, empathy, and intelligence. And perhaps above all, it requires a recognition of the judiciary's unique strengths and weaknesses and a deep and accurate understanding of our nation's most fundamental constitutional aspirations. We are in for a treat today. Please join me in welcoming our distinguished visitor, Professor Geoffrey Stone.
Thank you. That was the best introduction I've ever had. You can come with me every time I speak, Judge. And of course, I think it was the last of those points about what the world might look like if we had a better set of judges. Judge Hamilton was on the panel of the Seventh Circuit, which a week or so ago held that there is, in fact, a constitutional right to marriage equality. I'm delighted to be here. I want to thank the Provost's Office, the Dean's Office, and the American Constitution Society for making this possible. Having been a dean and a provost, and having been chair of the board of the American Constitution Society, I understand what great judgment each of those institutions has, and therefore appreciate the fact that they have supported this event. And I also want to thank specifically my good friend and one of my personal heroes, Professor Dawn Johnson, for inviting me to be here today. So what I want to talk about this afternoon is not quite specifically the Constitution, but rather this business about the NSA and about this rather unusual experience that I had being on a member of the review group that President Obama appointed last August to advise him about the various revelations that came forth from Edward Snowden about the policies, practices, and programs of the NSA, and particularly about how those programs could be evaluated and improved. And I should say that when we first met with the President in the Situation Room, he made clear that our charge was not to pontificate about the constitutionality of these programs. Several of our members were not lawyers, and I'll explain in a moment who they were, but rather he wanted a judgment about assuming these programs are constitutional, should we do them? Right? And that's what framed the enterprise that we undertook. So the way this began for me, and I'll tell this a bit as like a journey. The way this began for me was I was sitting in my office in August a year ago, working on a book, having nothing to do at all with the NSA, when the phone rang, and it was a former student of mine, Lisa Monaco, who works in the White House. And Lisa said that the president was appointing this group who would advise him about the NSA's programs. And Lisa was calling to ask if I, on behalf of the president, if I'd be willing to serve. And I have to admit, my initial response to that was my morale just dropped. Here I was completely focused on this book I've been working on for several years. I was hoping to finish it last summer, and all of a sudden, I get asked to do this. And although it might seem that this is exciting, my initial reaction was, presidential commission reports are a waste of time. They're well-meaning, but they disappear. Nobody ever hears about them again. Why do I have to do this? But you can't say no to a former student. You should all remember this, by the way. You can't say no to a former student. You can't say no to a former colleague, as in the president. And you especially can't say no to a former colleague who you hired when you were dean. And so with great reluctance, I said to Lisa, of course, Lisa, I'm happy to do this. And, but I figured I had an ace in the hole, because one of the things she told me is I would need a top secret clearance. And I've led a not perfect, not unblemished life. And I figured this probably would save me. And in particular, I had something which I figured was going to kill this. Because 6 months earlier, my brother, who's a lawyer in Maine, was diagnosed with cancer. He's fine now, actually. But he was diagnosed with cancer, and I went up and visited him. And as soon as I entered the front door, he comes up to me with this black plastic box, and he says, "We're going to have such a great time." It turns out it's medical marijuana in Maine. He says, "We've got strawberry, we've got raspberry, we've got spearmint, we've got nighttime, we've got morning, cinnamon, it's going to be great." So, A, not knowing I was going to be asked to be on this top secret presidential commission, and B, not wanting to disappoint my brother, who was truly excited about all this, we indulged most of the weekend. And so I figured, I have to disclose this, of course, so I'm dead anyway, it's fine. And so when this woman comes the next day to interview me for the clearance process, the first thing out of my mouth is I told her pretty much what I just told you, expecting her to close the book and say, "Well, I'm sorry, this isn't going to work," and leave. Nothing. Nothing. Not even a blink. Not even of any interest to them. So the next thing I know, a couple of days later, on a plane to Washington. And I meet this group of individuals, one of whom I knew very well, and the other three were complete strangers. So first let me tell you about who they were. Richard Clarke was a former member of the National Security Council, the first cybersecurity expert in the White House, and a member of the Defense Department, had been a member of the Defense Department. Mike Maurer was former deputy director of the CIA and twice had been acting director of the CIA, recently left, only a few weeks earlier, left the CIA, and was, from his standpoint, somewhat unhappily tapped by the president to come back and do this, having just left after 20 years in the agency. The third was Cass Sunstein, who was the one I knew well, was a former colleague of mine at the University of Chicago Law School. He'd worked in the Obama administration for 4 years in the Office of Management and Budget in OIRA, and had just left the government to go to Harvard Law School. And Peter Swire, the fifth, was a professor at Georgia Tech, who had been the director of the Office of Information and Privacy Technology in the White House under Clinton, and then was back doing some advising work under Obama. A very diverse group, coming to this from completely different perspectives and values. So I'm this ACLU type. I'm the one who's sort of on the extreme left of the group. And then you've got Clarke and Morrell, who are deeply involved in, knowledgeable about the intelligence community, and come to this exercise very much from that perspective. And you've got Sunstein and Swire, who are more moderate on these issues. And so we meet together in a SCIF, which is a secure facility, which you have to have a top secret pass to get into. And we have a full-time 9-member staff who had been tasked to us from all the various agencies, the NSA, the Director of National Intelligence, the CIA, and so on, FBI. And we sit down together, introduce ourselves to one another, and the first thing we sort of ask is, well, what are we going to do when we disagree? Right? We have to write this report. The report's due on December 15th. That's what we'd all been told right from the outset. Here it is, August 26th. What are we going to do when we disagree? Because obviously we're going to disagree with each other. Are we going to have dissenting parts of the report? Are we going to note disagreements in the recommendations? What are we going to do? And we talked about it for a few minutes, and we decided, well, we'll worry about it later, right? Well, I tell that part of it because one of the fascinating personal aspects of this experience is that in the end, we came up with 46 recommendations, all of which were unanimous. And they were genuinely unanimous. It was no, well, I'll give you this one if you give me that one. In the course of this incredibly intense experience, in which we spent basically 4.5 months together, 5 days a week, 12 hours a day. We came to understand each other's perspectives, to learn from one another, to respect each other's ideas and values and interests, and actually came up with these 46 genuinely unanimous recommendations, which was really just, in terms of interpersonal dynamics, in itself kind of an extraordinary experience. Okay, so then we get put in one of these black vans you see, the presidential motorcades, and we get taken to the White House and meet with the president and with Susan Rice, the national security advisor, and Eric Holder, the attorney general, and several other officials to talk about what our charge is and so on. And basically we're tasked with coming up with a report by December 15th, evaluating NSA programs across a broad spectrum, and we're given a good deal of authority with which to carry out this charge. So just a word on what we did over the course of those months. So basically, I was in D.C. I would leave every Sunday, leave Chicago every Sunday, and I'd come back usually on either Wednesday or Thursday nights. And that was true for all 5 of us. And what we did when we were in D.C., we'd spend about half the time in briefings. And so we would meet with, for example, the Senate Intelligence Committee, the House Intelligence Committee, the Senate Judiciary Committee, the House Judiciary Committee, many individual members of the Congress who wanted to meet with us either one-on-one or sometimes in small groups that they put together. We met with, on many different occasions, with the leaders of and officials in the NSA, the CIA, the FBI, Director of National Intelligence. We met with the Treasury Department, the Commerce Department, representatives from Facebook, Microsoft, Google, AT&T, Verizon, all of whom had very important interests in the issues that we were deliberating with. We met with the ACLU, with ACS, with members of the Federalist Society, with representatives from all of the various privacy and civil liberties organizations in the nation, as well as international organizations, representatives of the European Union, on and on and on like that. Now, when we began, as I said, my belief was that this was a waste of time. That however much I might learn from all this, in the end, we'd write a report and it would disappear. But an interesting thing happened during the course of this, which is that the more people we met with at our request, the more people got nervous that we might actually make a difference. And so they started wanting to meet with us. And the more they wanted to meet with us and did meet with us, the more other people got nervous and wanted to meet with us. So over the course of these months, by the time we were done, we basically met not only with everyone we wanted to meet with, but with an awful lot of people we probably didn't want to meet with because they wanted to have a voice in this process. Okay, so let me give a little bit of context for the enterprise, okay? So after 9/11, which frames, of course, a lot of what these NSA programs are about, after 9/11, Jim Baker, a member of the cabinet, made a comment which was quoted in a book by Jack Goldsmith about the War on Terror and the administration, which, when I read it at the time, struck me as really powerful. And it was part of what framed, I think, our mindset in this. And the comment was this: trying to keep the nation safe after 9/11, right, was like being the goalie in a soccer game where the opposing players can score from any side, including from behind you, where the opposing players are invisible, and where the ball is invisible, and where if they score, 3,000 people die. And you're the goalie. And you've got to look for anything, any movement of a blade of grass, right, that can give you a hint of where they are, where the ball is. Right? And if you fail, it's a disaster. Well, I found that when I first read it, as I said, very compelling. And I think that mindset frames a lot about what it feels like to people inside the government who are tasked with keeping the nation safe in this new world that we've been living in ever since 9/11. Part of the reason for that is because what we ordinarily rely upon to keep ourselves safe is deterrence. Right? Basically, the criminal justice system and the international order rely upon deterrence to minimize the degree of danger that we face. Right? People know that if they do something bad to us, we will do something bad to them, and that usually, obviously not always, but usually deters them from doing something bad to us in the first place. And that's a critical part of how we generally keep ourselves safe. After 9/11, it became clear that there is no deterrence. Deterrence is irrelevant. The people you're worried about are not part of a nation state. There's no one against whom you can retaliate if they do something to you. And they're willing to die. So the primary mechanism that we use to guard our own security doesn't exist. And that creates a huge vulnerability that was largely unanticipated and novel in terms of trying to figure out what you do in this situation. And the second aspect of it is that in that world, information is critical. Right? You're looking for movements of the blade of grass. In a world of billions of people, you're looking for a relative handful who are working together to do potentially severe harm to your people. And you can't deter them. So you have to find them before they act. Right? That's the mindset from which these programs evolve. And that mindset has to be taken quite seriously because it's legitimate. Right? The second thing about this that helped frame, I think, for us the enterprise is the understanding that whenever we as a nation have faced a crisis that threatened our people, we have, human nature being what it is, overreacted. We have erred dramatically on the side of our own safety, which is understandable. This is true in the Sedition Act of 1798, it's true in the Civil War, it's true in World War I, it's true in World War II with the internment of the Japanese Americans, it's true in the McCarthy era, true in the Vietnam War. Repeatedly, we know, predictably, we know, that faced with a crisis that threatens our security, we take extraordinary measures in the moment to make sure we're safe. And inevitably, those measures will overreach. They'll go beyond what's necessary because better be safe than sorry. And one of the critical things a nation like ours needs to do in those circumstances is, after an appropriate period of time, to take a step back and say, okay, what have we done? Right? Let's fix it. Let's recalibrate. Knowing that we've gone too far. Let's now recalibrate. Let's see what works, what doesn't work. Let's not be so inclined to err on the side of safety. And that's basically what our job was. Our job was to go back and, knowing that the dangers are real and the threats are serious and potentially grave, that we, human nature being what it is, we went too far. Say that without even knowing what we did. We went too far. And the question then is to figure out, where have we gone too far? How can we fix it? How can we balance better the concerns about security and liberty and privacy? One thing I recommend to you, by the way, is to read our report. You can get it for free online, or you can buy it on Amazon. If you simply Google liberty and security in a changing world. I get no royalties from this. It's a public document, so I have no self-interest here. But we intentionally wrote this report for you. Right? It was not written for experts. We wrote it specifically to inform the American people about how to think about these issues, about what programs we actually are doing, what's wrong with them, what's right with them, and how they can be redesigned. So let me give you a couple of examples of the kinds of issues we addressed, among many more I'm not going to talk about. And I'll mention three things briefly. The first is the Section 215 telephony metadata program, which has gotten huge amounts of attention in the United States. I'll explain in a moment what that actually means. Second, I want to say a word about national security letters. I'll explain in a moment what that is. And third, about the Foreign Intelligence Surveillance Court. And I want to address those things because they're particularly relevant to American citizens and because the dynamics in the process about them were actually pretty interesting. So the program that Snowden revealed that has gotten the most attention in the United States is the Section 215 telephony metadata program. So what that means in simple terms is that after 9/11, Congress authorized the NSA government to be able to obtain records from holders of those records, banks, telephone companies, car rental companies, whatever, all sorts of businesses, when they have reasonable grounds to believe that the information obtained in the records is relevant to terrorist activity. And to do that, they had to go to the Foreign Intelligence Surveillance Court to get an order, to issue what's called a Section 215 order. In 2006, the Foreign Intelligence Surveillance Court interpreted that provision to allow the telephony metadata program. So what does that mean? Under this program, the NSA wants to do the following. They have reason to believe that there is a terrorist somewhere in the world outside the United States. They know that person's phone number. They want to know whether that person is talking to anyone in the United States who is also suspected of being a terrorist. Because if he is, they want to know that. That's important. Right? You're essentially connecting the dots, the phrase that came out of after 9/11. Right? So the telephony metadata program allows them to do the following. They collect from certain phone companies, not all of them, kind of random, all of the phone records of all of the persons who use those companies. It's a bit like your bill, if all of your local calls were itemized. Basically, it's a list of every phone call made or received by every phone number, which gets swept from the phone company into the NSA database. Right, so they've got this massive amount of information authorized by the FISA court, Foreign Intelligence Surveillance Court, right, which they gather, put in their database. So if you think of it for yourself, it's every phone call you've made or received for the last 5 years. Right? They don't know who the people are. They don't know who you are. They don't know who the people who you're calling or who called you. They just know numbers, right? Billions of numbers. And they put all that in the database. That's the first part of the program. Second part of the program is when the NSA determines that they have reasonable grounds to believe that a particular phone number belonging to a person outside the United States is a suspected terrorist, they can query the database. Essentially, that means type in the phone number of the suspected terrorist outside the United States to see the numbers with which that person is in contact. Right? And what they're looking for is that person in contact with anyone in the United States who has already been identified, whose phone number has already been identified as a person who is a suspected terrorist. Right? They're looking to connect the dots. X is talking to Y, we got a problem. And if they find that, they turn that information over to the FBI for further investigation. Okay? Under this program, they also do what they call a second hop. The first hop, HOP, is the first inquiry, the first query I suggested. The second hop is they will look at the phone records of all the people called by X in the first instance, all of their phone records, to see if any of the people they've called is independently known to be a suspected terrorist. So if X, the person in Pakistan, called over the course of 5 years 100 different phone numbers in the United States. The first hop would examine those 100 numbers to see if any of them is already a suspected terrorist. The second hop would look at all of the people called by those 100. So if each of them called 100 people, it would be 10,000 numbers would be looked at. So they want to find, is X talking to Y talking to Z? X is a terrorist, Z is a terrorist, we got to investigate, even if we don't know who Y is, right? So that's what they're looking for. They're looking to find out if someone outside the United States suspected of being a terrorist is talking to someone inside the United States is a terrorist, or is talking to someone who is talking to someone who is a suspected terrorist. And if they find that out, they turn it over to the FBI. That's what the program does. Okay, so in 2012, which is the last full year for which we had data, the NSA queried the database for 288 numbers. Right, so there were 288 persons for whom they had reasonable grounds to believe they are involved in terrorism who live outside the United States. They queried their numbers through the process they just suggested. In 16 instances, they found a connection of the dots. That is, that the suspected terrorist outside the United States was talking to someone inside the United States, or was talking to someone who was talking to someone inside the United States who was already identified as a suspected terrorist. In all 16 of those cases, they turned the information over to the FBI for further investigation. Okay. In none of those cases in 2012 did that further investigation turn out to be a concern. In each instance, the FBI satisfied itself that this was not something that ultimately required any further investigation beyond the first inquiry by the FBI. Okay, so that's what this program, that's how it operates. That's what it does. Our recommendation on this program was that the biggest concern with it was that this huge amount of data is being held by the NSA, by the government, about all of your phone calls. You know, you call your therapist. If you're gay and you don't want people to know it, and you're calling your lover. All the stuff is in there, right? Who you call, about your political connections, about your religious views. And you can discern a lot about individuals by figuring out who they're talking to, right? So the concern we had about the operation of this program was primarily that even though there was essentially no abuse of the data itself that had been connected by the NSA, there were issues of noncompliance that were addressed, but there were no issues of intentional abuse of the data, that it's just sitting there waiting to be abused by somebody. And it's easy enough to imagine a world where you have a J. Edgar Hoover or Richard Nixon or some person like that in the future, right, who says, I want to find out who X is talking to, right? Because X is somebody, for whatever reason, I want to investigate, right? And then you've got in there a pretty good record of X's life. And so the concern was this is essentially a bit of dynamite that's sitting there, can be abused. So one of our recommendations with respect to the program was that the NSA, the government, should not hold the data. That basically one of two possibilities should be created. One is either that a private entity should hold the data that NSA has no direct access to without getting a warrant, or that the data should simply be left with the phone companies where it is anyway, and that when the NSA wants to investigate the data, it has to go directly to the phone company when it has those 288 numbers. It can't gather the data in advance. It's got to go to the phone company when it gets reasonable grounds to believe they have a number that is a suspect, and then the phone company can essentially do the inquiry for them. The other thing we recommended is that the NSA should not be allowed to make the determinations of reasonable or articulable suspicion itself, that they should have to go to the FISA court, a group of federal judges, to get the equivalent of a warrant before they can seek to get queries of the data. Both of those recommendations have been endorsed by the president and are currently pending in legislation before Congress, and hopefully will be enacted. There are still questions about the wisdom of these programs, but our judgment was that you could achieve the goals of the program, the security goals of the program, while dramatically reducing the risks of potential abuse with these two reforms. Okay, second example is national security letter. So national security letter basically is as follows. The FBI is empowered to issue an NSL, a national security letter, national security letter, to phone companies, rental car companies, whatever, same types of things, demanding that they turn over information about individuals who are suspected of having some involvement in terrorist activity. And the FBI can do it itself directly. And they do about 20,000 of these a year, an order of magnitude larger than the queries in the metadata program. Our judgment was that the FBI should have to get a warrant to do this, a court order to do this. Same standard, reasonable grounds to believe, but it should not be allowed to do it on its own. There have been plenty of evidence of abuse by the FBI in the application of this authority, and so we recommended that they should have to go to a judge to get it in order for the national security letter. The director of the FBI, Jim Comey, who's a former student of mine also, strongly objected to this, argued that it was unduly intrusive in the FBI. To our disappointment, the president agreed and decided not to follow this recommendation, and basically left with the FBI the authority itself to demand this information be turned over. The key issue here is that they argued this is like a subpoena. A prosecutor can issue a subpoena, doesn't have to go to a judge, and this is no different than that. It's the FBI instead of the prosecutor, but it's really no different than a subpoena. And our argument is that what they were missing is that when the prosecutor does it, right, it's part of a public criminal justice process. And the individual who is ordered, or the organization that's ordered to turn over the information, and the target of the information will ordinarily learn about it and be able to contest it in court after the fact. With the NSLs, it's all done classified. So the company, the phone company or the car rental company that receives an NSL is not allowed ever to disclose, 50 years, to disclose that they received the NSL. And the target of the NSL will never know that the government is investigating them. And therefore, there's no opportunity for an after-the-fact challenge to the legality of the order. And in that situation, we felt this is different from subpoenas because there is no opportunity otherwise for judicial oversight, and that therefore the NSL should require a court order. The third issue I'll mention is the Foreign Intelligence Surveillance Court. So the FISC, that's not symbolic of anything. The FISC was created in the late 1970s after the revelations of abuses by the FBI and the Johnson White House and the Nixon White House, J. Edgar Hoover, in their investigation of American citizens with respect to investigations of their loyalty and activities and political interest and so on. And before then, the assumption was that when the president wanted to investigate for foreign intelligence purposes, he was carte blanche. So if a prosecutor or a police department wants to put a search warrant or wants to put a wiretap on your phone for a drug investigation, they have to go to a court and get an order, a search warrant, right? In the foreign intelligence context, up until then, the assumption was that the president can do this completely carte blanche, including wiretapping American citizens in the United States. No need to get an order, no need for probable cause. Basically, it's up to the president. In the Foreign Intelligence Surveillance Act, Congress basically said, no, from now on, even in the realm of foreign intelligence in the United States, the president has to get a warrant based on probable cause to do a wiretap. But you couldn't do this with regular courts because regular courts don't have clearances, classification clearances. And when we're dealing with foreign intelligence, we're dealing with information that generally is classified. So the Foreign Intelligence Surveillance Court was created in order to have a judicial body that does have top secret clearance operating out of a secure facility that is able, therefore, to decide whether a warrant should or should not issue. So it's a major change, a huge reform in the right direction, right? So with respect to the Foreign Intelligence Surveillance Court, one problem that two problems emerged in our process that we felt needed to be rectified. First is that the Foreign Intelligence Surveillance Court operates in secret, and it's not an adversary system. Right? The government comes to it and says, we want a warrant or we want an order, like the telephony metadata program, we want an order, and the judges decide whether to grant it or not. But nobody's there on the other side. Right? Nobody's there arguing, wait a minute, there's good reasons not to do this. And one recommendation we made is that there should be a privacy and civil liberties advocate who operates within the confines of the Foreign Intelligence Surveillance Court and who's able to, as in a regular court, right, represent the other side of the issue to make sure that the judges are hearing advocates from both sides. And the White House has accepted part of that, and the legislation has accepted part of that. Basically what it has done is say there should be such an advocate, but instead of it being an individual who is independent and able to constantly monitor everything going on in the court, it would be a situation where the judges could call upon a pre-identified advocate when the judges thought the intervention of that other position would be useful. So what we recommended was that this advocate be independent and be able to decide for herself every time she wanted to intervene. What the compromise that was reached was that instead the judges would decide when they wanted the intervention by the advocate. And the final point I'll make is about the selection of judges for the FISC. So the Foreign Intelligence Surveillance Court consists of sitting federal judges who are identified for a period of years to, on a rotating basis, sit in the Foreign Intelligence Surveillance Court offices in Washington, D.C., to hear all of the various issues and requests for orders and warrants that come through the Foreign Intelligence Surveillance system. And what the Congress did in creating the court, one question was who would appoint the judges? Who would appoint which sitting federal judges would sit on the court? And they didn't want the president appointing the judges because the whole point of this was to be a check on the president. So you didn't want the president simply appointing a bunch of flunkies, right? So they decided they'd give the authority to appoint the judges to the Chief Justice of the United States, right? So since the Foreign Intelligence Surveillance Court was created, there have been three Chief Justices, Berger, Rehnquist, and Roberts. Berger and Rehnquist both appointed judges to serve on the court, more or less equally from judges who've been appointed initially by Republican presidents and Democratic presidents. Chief Justice Roberts, in the first 7 years of his service, appointed 10 judges who'd been appointed by Republicans and one who was appointed by Democrats. And we recommended, in light of that, that the Chief Justice should no longer have the authority to make these appointments because they were not being made in an appropriate manner. And our recommendation was that the authority to appoint should be spread among the 9 justices, with each of them getting to appoint a particular seat on the Foreign Intelligence Surveillance Court. That was not accepted as a recommendation. We knew it wouldn't be. The mere fact of making the recommendation would end the problem. And in fact, the last 3 judges Roberts appointed were all Democrats. So our sense was the exposure of that issue and the embarrassment caused by the exposure would solve the problem. Okay, I'm going to stop at that point and leave some time for questions. We have microphones, so over here.
Hi, thank you so much for coming. I'm Richard Benson on 1L here, and I'm very curious. It's so easy to be cynical in my generation about this entire process, and should we have faith that we can bring back more of our privacy rights through the process you just described and the reforms proposed or changes actually going to happen?
So that remains to be seen. The president has instituted some important recommendations that he could do with his own authority. I believe that the reforms that are now pending in proposed legislation in Congress would make a big difference. I believe that, in fact, if the members of Congress simply were able to raise their hands and say vote for or against, it would overwhelmingly pass. Because this is interestingly an issue on which many conservatives agree with the more liberals on the question because it has a libertarian flavor to it. But given Congress, who knows what will happen, right? So I can't say that with respect to some of these issues, change will occur. The most important factor in favor of this is all of these programs have to be reenacted on a regular basis. And the existing programs all expire in a year. And so Congress has to enact new legislation. So it can't just leave it alone. And therefore, I'm pretty confident that in the end, most of these reforms will be adopted. Now, are these reforms exhaustive of all the things that one could do? Well, of course, that depends on how you strike the balance between security and liberty. One might say that we should get rid of all these programs, right? They're all intrusive on our privacy in some degree. And the question is, how do you decide how much insecurity you're willing to live with in terms of national security versus how much privacy you're willing to sacrifice? Our judgment was that it is possible to strike a much better balance than the one that existed before through our recommendations. Whether that's ultimately the right balance is contestable. Right? Different people will have different views on that. In terms of cynicism, let me say a couple of things. First, I think that one thing that shocked me was that I found the NSA to be an institution with a high degree of integrity and commitment to exercising its authorities in a proper manner. This is not a problem with the NSA running amok. The NSA, in a sense, is a military-type institution in its culture, in the good sense of the word. They follow orders, right? And they don't make up the programs. They are executing the programs that are being authorized by the executive branch, by the Congress, and by the judiciary. And so, in my view, the attention here has been, unfortunately, has been focused on the NSA in the public discourse, when it really should be focused on the three branches of the government, which are responsible for authorizing, approving, and monitoring these programs. And on that score, my view is that although all of them mean to do this well, I think there is a good faith sincerity on the part of the members of Congress on these committees, on the part of the Department of Justice, on the part of the judges on the FISA court. I think they don't do it as well as they should. And by that, what I mean is it's a very seductive world of national security. And it's very easy to start looking at the question of, are we following the authorities correctly rather than have we given them the right authorities? And so I think the question that the oversight mechanisms, and there's lots of oversight mechanisms, and they're all acting in good faith, but I think what happens is they wind up asking the question of, are they following the orders rather than when are we giving them the right orders? And that's the question that needs to be revisited in a much more aggressive way, especially given this phenomenon I started with about the temptation to overreact and to go too far.
What recommendations did you make regarding online privacy in the PRISM program?
We basically regarded any access. So the PRISM's complicated because it's a 702 program and it involves it's targeted at foreign individuals. And I haven't talked about that here because it's a whole different domain. So I think it's best not to try to get into that because I have to explain what PRISM is and I have to explain what 702 is, and given the time involved, there's not enough time to explain it. But the bottom line is, our view is that with respect to intelligence directed at non-US persons who are outside the United States, that the government does have much greater authority to intercept communications than it does with respect to communications that take place inside the United States or by US persons when they're outside the United States. And that's what PRISM is basically about. And so it's a whole different set of issues of what are the obligations we have to people who live in Pakistan or in Afghanistan or in Germany, for that matter, in terms of their privacy rights, right? Are they the same as our privacy rights, or are they different? And if they're different, in what sense are they different? That's a huge set of issues involving the NSA programs, but given the time constraints, I didn't get into that. Down here? Oh, okay, you got the microphone.
Hi. When the commission was framing these 46 recommendations that you all were able to agree on, How much did this factor from a couple of questions ago weigh on your minds in the sense of, did you try to frame suggestions in ways that could be implemented by executive order versus requiring action from Congress, or vice versa?
Most of our recommendations were directed to Congress because the president didn't have the authority to implement the recommendations. The ones that, I mean, we were clear in our recommendations whether we thought this is something the president should do when he had the authority to do it, but I would say the vast majority were called for legislation because the only way it could be implemented was by legislation. We were very much conscious of who was the target of the recommendation.
You recommended that we need to hold the elected branch more accountable in giving better orders. And that kind of touches on one of the big problems that I haven't heard you talk about, is that the transparency on these issues has not been good. They're issuing judicial decisions in secret. James Clapper's going in front of Congress and lying directly to Congress with no consequences. And so when the public doesn't have the information to make decisions, they don't know who's being targeted, and the Congress is being lied to, how can we act responsibly oversee these programs?
So the transparency issue is huge, right? We wildly overclassify, right? We classify far more material than we need to, no question about that, and that's a serious problem, and one that we've been wrestling with for 40 years, and it's very difficult to get a handle on, but it's a real problem. And the second issue is I want to come back to the Clapper point because it's an important one. So James Clapper, who was director of national intelligence, was called to testify in an open session of Congress, and asked, basically, before it was publicly disclosed, whether the U.S. was gathering phone data about millions of Americans. And this was, at the time, a classified program. He was asked the question by Senator Wyden. Right? In my judgment, Wyden had no business doing that. Wyden knew all about the program. He was on the Senate Intelligence Committee. Right? He knew it was a classified program. Right? You cannot ask, in that situation, someone who possesses classified information about the classified information. If Wyden wants to shoot his mouth off, let him get up and make a speech and say, I know about a program that's classified. He didn't have the balls to do that, frankly. So instead what he did is put Clapper in an impossible position. Right? And did Clapper lie? Yes, literally. Did he have any alternative to that? I don't think so. If he said, I can't answer the question, everybody would have known that was yes. Right? So I think Wyden actually deserves to be taken to task for that. If Wyden wanted to reveal the program, do it. And take the consequences. Right? So on that score, I do think Clapper's gotten a raw deal on that. I've thought a lot about what would I have done in his position. I can't imagine I could have done anything but what he did. But I want to come back. The transparency issue is a huge problem, right? And you're right about that. And the issue is not that in general that the Congress is being lied to. It's that the Congress has decided to authorize all this material to be classified and to keep it secret. Congress has the authority to declassify lots of this stuff, and it doesn't do it. And that's where I think the real responsibility rests. I think it's 5 after, so we have to end. Okay, 2 more questions? We have any?
Hi.
Yeah.
My question would be, how do you view Edward Snowden in light of what was brought to light and what his actions were? Like, do you view them as criminal? Like the long-term effects on our society?
So there are a couple of ways of thinking about Snowden. One of them is that in a world in which you have classified information, some of which really needs to be classified, because disclosing it will significantly undermine the ability of the nation to be safe, right? You don't want relatively low-level government officials, or in his case, private contractors, making the decision for themselves what's in the best interest of the nation. That can't be the right way to run the government, right? That you don't want an incentive structure in place that leads people in the position of millions of people, keep in mind, millions of employees in this position, to think that they can decide. I don't think we need to keep this secret. particularly because most of the time they don't have any idea how what they know fits into everything else. Right? So I think the notion that it's okay for someone in a position of Snowden to make the choice for the nation that programs that should be disclosed is a really bad way of operating and a real problem, a huge problem. That's number one. Number two, if you ask, did Snowden do us a favor or did he do us a harm? Right? I think you have to divide his disclosures in two. On the Section 215 program, the metadata program, which is the one that most Americans have been interested in, I think on balance he did us a favor in the sense that we are having good debates, probably will make substantial changes in the program, and the program itself I think was not that effective, so that the disclosure is all that costly. So I think one could make the argument that the benefit with respect to the disclosure of that program objectively outweighs the harm. With respect to everything else he disclosed, which is 99% of it, I think the benefit is almost non-existent. No one in the United States is talking about changing the programs that involve intelligence of foreign citizens outside the United States. But that's the vast majority of Snowden's disclosures. And those programs, unlike the Section 215 metadata program, are very effective and very valuable. And they've been significantly undermined by making them known, because basically it enables people to avoid doing the things that they were doing before that we were able to overhear. So I think I would say if the question is, has he done us a benefit or a harm, with respect to 215, if that's all he had leaked, I think one could say, if it's the right question, which it may not be, he may have done more benefit than harm. But with respect to the entirety of what he revealed, I think clearly much more harm than benefit. I mean, and part of the problem the government has in explaining the harm is that when they prevent potential attacks, they can't disclose any of it because it would reveal sources and methods. Because if they said, we stopped these attacks, the media would say, oh yeah, tell us how you did it. We don't believe you, right? And they'd immediately be put in the position of having to reveal information that they can't reveal without threatening the lives of people and without undermining their own programs. So one of the really interesting frustrations from inside the NSA is the complete inability to explain what they achieve, right? Having been inside that world, I can tell you they achieve a lot. And much more than I would have imagined when I entered this picture. And not only preventing attacks on the United States, but much more preventing attacks around the world. And that's part of the dilemma, is that they're gathering this information for a reason. And even though it's a huge amount of information, and it's easily subject to abuse, and it's dangerous for the government to have it, it also has a payoff. And the difficulty with public discourse about this is they can't talk about the payoff. I actually talked to Keith Alexander, the director of the NSA at the time, about you should be doing more of this. And we had a long discussion about, well, how do you do it? And he was right. He persuaded me that, frankly, you can't reveal very much because as soon as you do, you reveal too much. And it's a real dilemma. Yep. Thank you all very much.